That being said, I'm Allie Chris. For those of you who don't know me, I'm a financial planner and the president of Financial Insights here in Tacoma. We're doing wealth management, retirement planning, and education in our community. So just a few other things before we start. I already said the questions. We will offer questions again at the end, and then at the very end of the session, I'll go through some of our other educational opportunities coming for the rest of the year. So a little bit about Brianne. So Brianne, an attorney here in Tacoma, Washington. She's been practicing in the areas of estate planning, probate, and trust administration in the South Sound for almost 20 years. She enjoys working with clients to create lasting estate plans and advise executors and trustees in the administration of all types and sizes of estates. She received her JD from Seattle University School of Law, her BA in English Literature from the University of Portland, and attended Bellarmine Prep right here in Tacoma. Over the past 2 years, she and a few partners purchased and renovated a beautiful brick building in the North End, which now houses her practice. Currently, Brianne lives in Gig Harbor with her husband, Brian, and her 2 kids, Kate and Max. In her hours outside of the office, Brianne loves running, reading, cooking, playing with her kids, learning about entrepreneurship, and appreciating the beauty of the Pacific Northwest. So all that being said, welcome, Brianne. We're very happy to have you. Take it away.
Thank you. So I'm so happy all of you guys are here, and I am going to go ahead and share my screen with my very technical presentation that I put together with the help of my 13-year-old daughter because things have come a long way since the last time I did a slideshow presentation. So hopefully this works out okay. I love talking about estate planning. I talk about it day in and day out on a one-on-one basis with clients, but it's just something that a lot of people don't know enough about. People have heard the wrong things. They just have misinformation in their head, or they're scared or intimidated by it. They think it's not for them for various reasons. So anyway, I like to dispel the rumors, give people the overview of what it actually means, because a lot of people don't really know that. And then I like to, let's normalize this conversation. A lot of people don't like to talk about estate planning because it involves, as I said on this slide, death, taxes, and all the fun stuff that no one ever wants to talk about. And I just find that to be true kind of across the board. But like a lot of things that we don't want to talk about or deal with, estate planning is one of those things too, where once you do start talking about it and you address it and you get it done, you just feel so much better. It's like a huge weight is off your shoulders. So it's something that's really important. And we're going to talk extensively about why it's important. Just maybe before we get totally going on this, I just want to say that while I'm sharing my screen with everyone, I don't really have the functionality to see when questions come in. So if there's something that that I'm not seeing, maybe Katie or Allie will see it and say something. Please pop in and say something, interrupt me. I don't mind being interrupted. I'm happy to answer pertinent questions kind of as we go, but there will be time at the end to ask any question that you have too. So please don't be afraid to ask any question. There's no question that's a stupid question here. And like I said, most people don't know a ton about this. So let's learn together. So Allie already introduced me. I would just say maybe as a few human interest items about me that are different from my professional career. I also own another business, a candle making business, which surprises people sometimes, and that lets me be more creative. And then obviously the most important parts of my life are my kids and my dogs and my husband and nature. So that's kind of what I'm into. My most, I guess my guiding principle when it comes to being an estate planning attorney is that for me, yes, taxes are an important thing to know and talk about. Wealth planning is an important thing to deal with, but kind of on the flip side, I really think that because so many people don't have their estate planning done, my highest goal is to help as many people as possible understand and have a plan that will work. So my goal is to make it accessible, understandable, not scary, and not intimidating. So that's where I'm coming from. I just try to bring it down to a regular level, have a normal conversation that doesn't include tons of legalese, because that tends to make people uncomfortable and then you just don't maybe take as much from it. So here we go. What is estate planning? So when people say estate planning, generally what they're talking about is a main set of documents that would control in different circumstances. So the very main estate planning document, you all know what that is. That's a will. So if you die, Your will says this person should be in charge and they should figure out what needs to happen. If I die, here's how I want my estate to pass. Here's how I want my kids to be taken care of. Maybe I have beneficiaries who have disabilities or have special needs of some type, and I can kind of provide for that. But that's the main point of a will, is just to say, here's the roadmap to follow if I'm not here anymore. In Washington, there's also another document that could take the place of a will. That's called a living trust. And living trusts are important for certain people and not for a whole bunch of other people. And we will get into that in more detail so that you can understand at least the basic framework for how you would determine if a living trust would be important for you versus just having a will. Along with the main part of your estate plan, the will or the trust, it's really important that people have durable powers of attorney. A durable power of attorney is a document that lets you nominate somebody else to make decisions for you if you're alive, but you can't make decisions for yourself. So I think a lot of times people get confused and they think, oh, I have a durable power of attorney and I've named this agent to act for me. And then they'll just keep doing that after I pass away. But powers of attorney are only effective while you're alive. And when you die, it's your will or your trust that would take over from there. So then I have a whole bunch of other people who think durable powers of attorney shouldn't be that important because I have a will. And what I like to point out is that durable powers of attorney may be more important to you personally than your will because you're alive and needing help or care or guidance at a time. And that's what the durable power of attorney does. So I always give this example to clients. If you are in a car accident and you're in the hospital in a coma and someone needs to sign paperwork for the doctor or consent to treatment for you, that's what the power of attorney is for. Let's say at that same time that you're in the hospital, your mortgage payment needs to be made and someone needs to sign a check and send it to the mortgage company. That's what the power of attorney is for. Basically, they can step in and do anything for you legally that you could do for yourself. Okay, and then moving on, working hand in hand with the power of attorney is a healthcare directive. And we'll again talk more about this as we go through the presentation, but sometimes people have heard that called a living will. And basically it's you saying what your final expression or hope for your end of life care would be. So we'll get into that. And then also in our office, when we do all the other documents, we usually also do a statement called a disposition of remains. And all that does is say if you prefer cremation or burial or composting these days, something like that, and any other specifics that you want. So that's what most people are thinking of when they think of estate planning. And that definitely is the basic pieces of estate planning. Along with that, in consideration with all those other things, we're looking at tax planning for you if you have an estate tax issue or not, or a potential one. We're looking at planning for incapacity. So if you're not able to make decisions, that's something that we want to talk about. We're planning for your family. So if something happens to you, how's your family going to be taken care of, especially if you have minor kids or you have someone in your family who requires something from you that would not just be immediately obvious to people around you. We're making sure the whole plan works together. So we're going to talk more about kind of ways that plans maybe aren't always synced up, but it's important when we do estate planning and we're talking about these basic documents that we're also looking at the other pieces of the puzzle to make sure that every single thing is going to work together. And then making sure your objectives actually happen. In my mind, estate planning is all about decision making. And I always think like we all live these independent lives. We make our own decisions. We have our own personalities. We have our own desires for things. Why would we just leave what would happen if something happened to you up to chance? We want to have as much certainty as we can with regards to certain things. So that's kind of the basics of estate planning. And then I think it's also important to remember that estate planning doesn't happen in a vacuum. So just like I was saying that when we do estate planning, we want to make sure the whole plan works together. Well, that might include consulting with more than just an attorney and you. So definitely you are the most important part of this team that makes the dream work for estate planning. And most often it works to talk to an estate planning attorney. Sometimes you can deal with online resources or form type resources, but those are not appropriate for most people simply based on the fact that we're all complicated and different and we all have our own things that we need to deal with. And it's hard to do that with a template-based system. So you, the attorney, if you have a financial planner or advisor like Financial Insights, we want to get them on board too. We want to talk to them and make sure that whatever plan you are thinking, A, they know the plan, And B, they can look at the things that you have, financial assets that you have, and make sure that if something's passing outside of the probate process, or your will's not going to cover it because it has a joint ownership or a beneficiary designation, they can help us get all of that lined up so that every piece is working together. Similarly, if you have any type of tax issues, we would want to pull in your CPA, your tax advisor, to make sure that we're all on the same page and that what we're doing is also in line with what they're thinking, and we're not doing anything that will create unnecessary taxes or create a situation that you could otherwise avoid. If you work with a personal banker or an investment rep or an insurance person, any of those people, that is important to things that are part of your plan, we may want to talk to them. And I usually like to open the door just by letting people know, okay, I'm working with this person. Do you have any questions for me? Do you need anything from me? Do you have information for me? Because I do find that sometimes clients are not, it's not that you're not great self-reporters, it's that you don't always know all the information that will impact the estate plan. And that's kind of across the board. So it's just nice to get all the team together. Okay, so a fun one that I like to talk about too is rumors that you might have heard. So when it comes to estate planning, there's a lot of stuff floating around out there. I know Allie knows what I'm talking about, but you just hear crazy things all the time. And it's hard for most people to discern whether something that they hear from their neighbor or their cousin or their uncle is true and they should take it seriously, or something that does not apply to them. And it's more complicated by the fact that all states have different rules that cover estate planning. So they may feel kind of similar, but then there are different implications in every state. So when you are hearing something from someone, first I would say you want to fact check it. And when you fact check it, you want to fact check it for Washington state law specifically, because we live in Washington and Washington state law is what applies to our estate plan. So rumors you might have heard. You don't need a will because you don't have a huge estate. You don't need a will because of community property and you're married, or because you don't have any kids. So what's the point? Or because you could just handwrite a will yourself. Those all make me laugh. And some of the ones I like to point out too are people who don't have children, people who have community property. They think like, oh, this is just really standard and run of the mill, but community property is just a presumption in Washington. So there are things we have to do from a legal standpoint in your will to make sure that things are dealt with properly. And then when you're living a single life, or you're living a life and you don't have kids, or you're living a life and you have a blended family with multiple, iterations of things, it's so important to have a will, because if you don't have a will, there's definitely a one-size-fits-all will structure that the state will give to us, comes in the form of RCWs. And for most people, the one-size-fits-all is not going to be how we would choose to leave our estates. So you want to do what's right for you, and you don't want to rely on a statute to make it happen for you. Other rumors that people have heard and come to me with are that they need to have a trust. That is not always the case, and we're going to talk about that in a little bit. A big one is probate is a nightmare. What can I possibly do to avoid probate? Again, that is a myth in Washington, and we'll talk about that later too. Only rich people do estate planning. Nope, everybody needs an estate plan. Everybody needs a plan. And I like to say too, if you put it in perspective and you think, okay, if I pass away and I don't have a will, certain things are going to be more expensive. My family might have more reason to fight about things. It might take longer in the probate process because there isn't a set system in order. People might fight over who should be in charge. All of those things add up to more time and more money spent with attorneys and the court. And a smaller estate, so an estate that's not a rich and wealthy estate, can less afford to have those expenses than a big, huge mega estate. So something to keep in mind, even if you don't have a ton, one thing that you can do to save costs in the long run is to have a will. Other people come in and say, well, I don't want the state to get all my money. And I laugh at that too, because just like I said, if you don't have a will, the state has a system that would be put in place for you. And only if you have 0 living relatives anywhere that could be found would the state get all your money. In my almost 20 years of practice, I've seen it happen one time. One time has the estate gone to the state because there were 0 living relatives. So that pretty much almost never happens. What would be more true than the state getting all your money is that relatives that you don't get along with or haven't spoken to or don't care about get your money, and that might actually make you more angry than if the state got your money. So something to think about. And then why does it matter? I'll be dead anyway. That's what people say too. I don't care, I'll be dead anyway. I always just think, well, if you have anyone in your life that you care about and that you love, you probably want to prevent them from having to deal with a huge chaotic mess after you pass away. It's just not a fun gift or memory to leave behind for somebody. So why is a plan important? We've kind of talked about some of these things, but a plan can do so many things. And you probably know all of the things that it can do. It provides a roadmap for people to follow. I always think if I'm heading out on a trip and I don't know, I don't have a map, I don't have directions to get where I'm going, the likelihood of me getting there is pretty low. I'm not great with just turn by turn on my own in my head directions, and neither are most people when it comes to settling estates. So let's give people a good plan to follow. Another thing that people don't often think about is that one important part of estate planning is deciding who is making the decisions for you. So when you're alive and under your power of attorney, someone is stepping into your shoes to make decisions for you. Do you want to leave up to chance who might be making decisions for your life? I don't think so. When it comes to your estate, we want to pick someone who is going to make good, solid, reasoned decisions. And you want to pick someone who's detail-oriented, who can follow along on your plan. We don't want to just leave that up to chance and maybe have your brother who's never kept more than $10 in his account at any time be your executor. Big problems can happen with that sometimes. Having a plan is important because it can make the process way simpler. In Washington, there are laws that say that you can elect certain shortcuts in your will. So we are going to talk about probate in just a little bit, so you'll know more about what probate is. But if you are in a state that's going through probate, if you have a will, you can elect something called non-intervention powers for your executor. And basically what non-intervention means is that once the will has been admitted to the court and the judge has looked at your will and said, yep, that's a valid will, they've looked at your proposed personal representative and done a background check and said, yep, that person's qualified to serve, then they basically give them the stamp of approval, and that person gets to go out and settle your estate according to your plans and do what is best without having to get court permission for every single thing that they want to do. And as you can imagine, someone going and doing what they're supposed to do versus going and doing what they're supposed to do and stopping every 10 days to go ask the court a question or get permission to pay a creditor or make a distribution can create a lot longer of a process and a way more expensive process. So having a will can save you tons of money on attorney fees simply by having the non-intervention powers. And then of course, it's providing a clear plan so the person knows what to do without having to guess or do a bunch of legal research or things like that. Having a plan is important because we can make sure the people in our life are protected and provided for correctly. So only you know the people in your life. You may have a husband who does not know how to pay a bill and he is going to need help with that. You might have a child who is dependent on you, even into adulthood. And maybe it's not a traditional type of dependency. It's not a legal guardianship. It's just simply someone who needs more assistance, and other people don't always understand that sort of thing. You might have minor children who need to have a place to go, to live. So all of those things we can cover in your plan, and just make sure that those types of things are just not traditional, or maybe other people don't necessarily understand the arrangement. It can be taken care of properly, and you pick people who can step in. You can talk to them ahead of time so that they can come up to speed and know how you support the people in your life. A big one why a plan is important is because you can support organizations that you believe in through your documents. If you die without a will, there is not a chance that any part of your estate is going to go to a charitable organization that you support. And for some people, that's not a big deal. For some people, maybe they do lifetime giving, or they're not involved with charitable organizations, so it's not a thing. But I find with most of my clients, they do have feelings about this and they do care. And the only way that you can make sure a charitable gift is made is to put it in your plan, or to have it listed in one of your financial investment accounts, or some other type of beneficiary designation. Because if it's coming down to what the law says, the law is just finding your closest living relatives. And I can tell you that if closest living relatives aren't charged with making charitable donations, they will not be doing it out of the kindness of their heart because they think that it would make you happy. They are going to receive what they receive and move on. And then finally, it's important to have a plan if you have any type of tax issues that we have to deal with, because we can drastically save money on taxes with just some very simple, basic tools. And we're going to talk a little more about taxes as we go. So who needs to do it? You know the answer to that. It's everyone. Everyone needs a will and a plan. It doesn't matter if you're rich, if you're not, if you have kids, if you don't, if you love your family, if you hate them, if you have tons of friends or not, you need to have a will because you are different and unique and your plan needs to happen. I just read a statistic, a new statistic just came out on a study that said that the percentage of Americans with wills has dropped to 32% of the population. And that's a drop from somewhere in the 40s. So somewhere in the 40s is not great, but somewhere in the low 30s is even worse. So this is something that we need to talk about with our friends. Something I hear a bunch with clients is, oh, I really need to talk to my parents about this. And I would agree, because typically, if your parents haven't come up with a plan, you are the plan. You are going to have to be dealing with it, and you won't maybe not know what they want. You might have siblings that you don't maybe agree or see eye to eye on everything with. And so it is important that people get this done. And I do find too that when people say, oh, I just got my will done, it sparks a conversation because a lot of people are curious and they are afraid to ask. So it's a great entry point to just tell people about your experience and how you did it. Not that that would apply to the person that you're talking to, but just to get the word out there, because it really is important. So things that can complicate estate planning: taxes, which we'll talk about. If you own real estate in another state, you have got to get your will / a trust done, because that can cause complications beyond belief when it comes to you passing away and dealing with that property in another state. Most people don't know that each state has jurisdiction over the property that's inside the state. So if I live in Washington, but I am so lucky, I finally got that condo in Hawaii that I've been wanting, and I don't do anything and I die, well, there would be a probate here in Washington because that's where I live and I've got stuff that needs to be transferred. But this probate in Washington is not going to do a thing when it comes to the Hawaii condo. I'm going to have my personal representative find another attorney in Hawaii. They're going to have to open a probate in Hawaii and then deal with my attorney here in Washington to get paperwork and kind of correlate everything. But basically why it's really important is because you're really doubling at a minimum the cost that you're going to be paying with probate. And I can tell you that we have a really good, solid probate structure here in Washington. It is simple. It is, for the most part, inexpensive. It is not super time consuming. Now that is all, the caveat is you might have something complicating that could cause it to be expensive or take longer. But for the most part, for a simple estate where no one's fighting, where there's not like estate tax to pay, it will not be very complicated. I cannot say that for other states, and notorious other states that are difficult for probate. Coincidentally, a lot of them are places where people have vacation property. So Hawaii, New York, California, Louisiana, a lot of places like that are really tricky when it comes to probate and very expensive and time consuming. So having your estate planning done is 100% important. If you've heard rumors or misinformation, that can complicate your plan simply because you have something in your head that maybe is not appropriate for your situation. If you have any type of family issue, you have people that you just don't want to include, you have a blended family with kids from various marriages, and you want to make sure that your kids are protected, and those are all things that make it a little more complicated than just a straightforward situation. It's also complicated because, just like I said, nobody wants to talk about it or think about it. I find people are strangely superstitious when it comes to estate planning. And it's almost like, oh, if I say it and have a will, I'm just going to drop dead. And I can say that that is not true. I do tons of estate planning work and wills and talk to my clients over and over again as they call to make changes. But so there's just a stigma associated with it that can make it more complicated. And then, like I said, the majority of Americans don't have wills. So here we go. What the heck is probate? I had my daughter help me with this graphic. As you can see, it's just a big pile of garbage and a girl pulling her hair out. And that is what people think probate is, and that is not the truth. It could end up like this if you don't have a will, or you have family members that fight about things, or you have major debt or creditor issues, then yes, maybe that would apply to you. But for the most part, probate is merely the process of taking what you have and transferring it to the people who you want to get it. And along the way, there are some things that have to be done. So if a probate is required, then there would be a formal court process where we go to court and we present your will and we ask for your personal representative to be appointed. It's pretty simple and straightforward. Through that process, we get an executor who's appointed, who has powers then to handle and settle your estate. They get to take over. Part of the process is figuring out if you have any debts or creditors that we need to deal with, and then figuring out all the things that you own, however you own them. We kind of just gather everything up, and I look at it as a big puzzle that we're putting together. And then we're also transferring what you own to who you want to receive it. We wrap up any loose ends. So if there's any paperwork that needs to be done or companies that need to be notified, we take care of that. And then a final income tax return, so not an estate tax, but an income tax return, has to get filed. And that's because typically people die somewhere in the middle of a tax year where they have earned enough income during that year that an income tax return has to be filed and filed. That's it. That's the word. So that's just the basic process of probate. When is it required? So probate is not required in all situations. Probate in Washington is required if you have more than $100,000 of assets that are probatable assets, or you have real estate. And it's an or, an and an or. If you have real estate, but you don't have $100,000 of probatable assets, you still go to probate. If you have $100,000 of assets that don't have another way to transfer, but you don't have any real estate, you still go to probate. I bet you can guess that having a will in the probate process makes it more efficient and less expensive. So probate, when I say probatable assets, so $100,000 or more of probatable assets, that means that there's not some other form of transfer that's going to apply to those assets. Probate's kind of the only thing left. A will make it more complicated or less complicated, but if you have no will, we still may have to go to probate. It's just the probate might be more drawn out. And we would generally not, in a case where you don't have a will and we go to probate, we generally will not be granted non-intervention powers. And typically the court will have a trade-off there. So there's an expensive trade-off one way or the other. If you don't have a will, then the court might say, okay, we will give you non-intervention powers and trust that this person is going to do a good job, but we're going to make this person post a bond to secure what they do, so that if they mess up or make a mistake, there is a way for the estate to have recourse. So you may have to apply for and get a bond before you can serve as the personal representative of an estate, or they may just say, no, we're not going to go with the bond. We're just going to require a full court intervention, which means anytime something has to be signed, paid, distributed, you have to put a petition into the court, show up, tell them why you're asking for it, and have them decide whether it's worthy or not and whether you can do it. So anyway, if there's a trust, so if you have a trust, which I'll explain more about trust in a little bit, but if you have a trust but you haven't maintained it, or you have a trust but you have assets that are not owned by the trust, like you set up your trust and you put your house in the trust, good. But then 10 years later, you sold your house and you bought a new house and you forgot that you had a trust. And so the new house is just in your name. Well, when you die, the house isn't in the trust. And even though you have a trust, the house still has to go through the probate process. So those are kind of the things that I'm looking at when I get a call from somebody about whether probate is going to be required or not. And one of the things I had talked about on the last slide about when probate is required is when things don't have another way of transferring. So in Washington, when someone dies, there are several ways that you can transfer assets that don't necessarily involve probate. So we just talked about what probate is. but you might have assets that are going to transfer outside of the probate process. And that's important for a number of reasons. So even if you're going to have a will, and even if you think, you know what, even with this will, the way my estate is, it is going to go through the probate process, that's totally fine. That's most people. There still might be assets that you have that are not going to be governed by the probate process because they have one of these other types of transfer. And it's important when we're doing your estate planning, when I was talking about making sure all the pieces work together, it's important to look at these things too, because they're going to do what you've said individually, and then the rest of your estate is going to fall under your will or your trust or the probate process. So other means of transferring assets in Washington are through joint ownership. So let's say my husband and I have a bank account together, it's a community property account. If I die, he just becomes the sole owner of the account. It's not going through the probate process. He just has to take my death certificate to the bank and they're like, oh yeah, okay. And they take my name off of it and it becomes his. And similarly with community property, depending on how we deal with community property, that could mean that things are passing outside the probate process. So let's talk about community property for a second, because I think people have a misunderstanding about how that works. I hear constantly, well, Washington is a community property state and I'm married, so everything is just going to my spouse, right? Not necessarily. So if you and your spouse are married and you guys have a bunch of things in your names together, what community property means is that things that are community property are considered to be owned by the spouses in an undivided 50-50 type of ownership. So that bank account I was talking about with my husband, let's say it has $10,000 in it. Well, I have an undivided interest in 5,000 of it, and my husband has an undivided interest in 5,000 of it. It's important to know what is community property though. So if you are thinking about things that you have, anything that you earn during marriage. So I'm going to work, I'm getting a paycheck, I'm contributing to my 401k, whatever. Those types of things are considered to be community property because it was earned during the time of the community. Anything that you owned prior to marriage. So if you have bank accounts from before marriage, if you set up a retirement plan before marriage and you're not contributing to it during marriage, that's considered your separate property. Anything that you receive during marriage or before marriage that is a gift to you from somebody else or an inheritance to you from somebody else is considered your separate property also. So you can see that the lines kind of get a little bit blurred here. Like, okay, so we can say, I had this account before marriage, so that's my separate property. Then I have this with my husband, that's community property. But the thing is that the community property is just a presumption. So in Washington, the way to make sure if you have an estate and you're married and you want everything to go to your surviving spouse if something happens to you and you don't want there to be a probate, one way to do that would be to formally sign what's known as a community property agreement. Those are not appropriate for all people based on tax situations, but the purpose and the point of a community property agreement is to say, if something happens to me, anything that I own, whether it's actually separate property or actually community property, I want it to go to my spouse and I want it to vest 100% in my spouse at the time of my death. So the community property agreement, if you have one and something happens to you, that will effectively transfer everything to your spouse without the need to open a probate. But most people don't have community property agreements or they don't know about them. And so if you don't have a community property agreement and you're married, your spouse has rights towards things in your estate, whether you want your spouse to have it or not. Allie, I see your hand up.
Thank you. Oh, you see it. So quick question that I have about community property that I don't quite even understand and would love the answer to, and I think some of my clients are confused. So typically speaking, all the assets, usually the intention is for them to go to the spouse 100%. But let's say we have a scenario where spouse one either has children from a previous marriage or spouse one wants their part of their 50% to go somewhere else and maybe is concerned that spouse two might either spend the money down, not give it to what first spouse's intention. So what are some options for that situation? And does community property, is there a way to protect that 50% for that first spouse's intentions that might be outside of the other spouse?
Yeah, so the first spouse to pass away, you may, yes, and it's very common. And blended families are way more common too. I mean, it just, almost every other person I talk to has just different types of family stuff going on. So It's a really common way to say, if something happens to me, I want my estate to go to my husband or my spouse, but I want it to go in trust, and that person can use and benefit from the assets during their lifetime. But when that person passes away, everything that's left in that trust is going the way I want it to go to. So that going to my kids from a separate marriage or something like that. You can also, you don't have to leave your community property to your spouse. You just have to remember that if you have community property, that means that it's a joint ownership. So you don't control 100% of that asset. You only control 50% of it. And you could leave your 50% to somebody else. Now, it's 100% a best practice if both people can know and be transparent with each other about how they want it to go. And if you do have a complicated situation with separate property and community property and different family members and a different kind of distribution thing, a really great idea would be to do something called a separate property agreement or a postnuptial agreement or a prenuptial agreement. But basically just saying, if something were to happen to me, this is all my separate property and I want my separate property to go how I want it to go, and I'll put that in my will. But we're both agreeing. There's no discord here between us, that everything that we came to this marriage with is our separate property, and neither of us is going to have a claim against the other person or the other person's kids for that stuff. So the best practice always is just to be clear with what you want to have happen, because we can always make whatever you want to have happen. It just won't happen automatically. You have to be clear about it. Okay, so let's go back to other ways of transferring property. So we talked about joint ownership of an account with someone, and I forgot to mention that sometimes when you set up a bank account, so I'm skipping above community property back to joint ownership. Let's say you set up a bank account, it's in your name, and then you get to a point where you're like, oh man, I'm just really tired of paying bills, and my son's over here all the time kind of helping me out. I want him to be a signer on my account so that he can sign checks and pay my bills for me. So you go to the bank with your son and you say, I want to add my son as a signer. And they're like, oh, great. And they give you paperwork to fill out, and you fill it out. What they don't usually tell you is that there really is no such designation with a bank to make someone a signer on your account, unless you're dealing with like a durable power of attorney. But otherwise, when they're having you sign the paperwork at the bank to add the signer, they're making that person a joint owner with you. And when they make that person a joint owner, they typically do it in a way that's called joint tenant with rights of survivorship. And what that means is that if you pass away, the person that you made the signer, the joint owner, is going to inherit that whole asset. So lots of times I see this in estates where, you know, a surviving parent is just having troubles and they have one child who lives close by who's kind of helping and carrying the weight of dealing with everything, and they've got other kids other places, and their estate plan says that everything should go equally to their kids. But because they've set up the situation at the bank, then when they pass away, that whole account goes to the one child instead of being divided equally. So just something to think about. But when it comes to probate, if you have assets that have other owners, typically that asset is going to go to the other owner and it's not going to go through the probate process. Okay, and then beneficiary designations are a big one. Almost everybody has something that has a beneficiary designation on it, whether it's your retirement account or a life insurance policy, an annuity, something like that. And when we're doing estate planning, it's important to think about that for a couple reasons. One, is it in line with the plan that you have? Because maybe it's not. And two, do you even know who your beneficiary is? So I usually have people, you know, I call it their homework, and I have them research their beneficiary designations and just make sure A, they know who it is, and B, it's still the right person. And if it's not, then at this point, while we're doing everything else, we can have Allie help us complete a new beneficiary designation form to make sure that it's getting split the right way. I had an account once that, you know, was after I was married, and then I looked at it and realized I still had my mom listed as my beneficiary because I filled it out way a long time ago, and then I just hadn't given it any more thought. So it's something just to think about, but just keeping in mind with this ways to transfer things. If your account has a beneficiary designation on it and something happens to you, that account is going to the person named in your beneficiary designation, and it's not going to become part of the overall probate process, which can be great. The TOD, the POD, so transfer on death or payable on death, same kind of thing. It's not going to be part of the probate process. And then if you do end up having an estate plan that includes a trust and your trust owns things, the things that are owned by the trust are not going to go through the probate process either, because the trust is its own means of transferring things. Does anybody have any questions about ways things transfer besides probate? Okay, so, yep.
Yeah,
Okay,
I
Faith,
just,
see your-
yeah, if you go back to the joint tenancy, is it, can you only have two people on the account, or could you put all, if you had three kids, put all three kids on? So they, and then would they inherit equally at that point?
Yeah.
And I know that it creates other problems, but that would be one solution to that?
Yeah, you're correct. It does create other problems, but yes, you can name more than one other person as a joint owner with you on a bank account. And then Faith, I saw your hand up too.
This is a new computer. I was trying to get to it. What is TOD and POD?
So sometimes accounts will have your name and then another name and then say TOD after it. And TOD means transfer on death. So if you die, that other person that's named next to the TOD is going to receive that asset, kind of like a beneficiary designation. Okay, so something that I end up talking to pretty much everyone about is, should I have a will or should I have a trust? And a lot of people come in saying, I need to have a trust. And that's how we start the conversation. And I want to say 7 or 8 times out of 10, I am talking myself out of a bigger job because trusts are definitely necessary in certain circumstances, and they're a great idea in certain circumstances, but in the vast majority of people, they're not the best option for people who live in Washington. So I like to start off with, what is a trust and what is a will? And we've already talked a little bit about this, but the will, you already know, you put it in place, you make the decisions about who's in charge, you make the decisions about where your estate should go and just kind of that whole process. And then you put it away and it's dormant until something happens to you, or you look at it, you know, as we recommend every 2 to 3 years and think, oh, I need to update this. You update it and then you put it back again. And it's not doing anything in the meantime. It's just waiting to spring into action. That's kind of nice because you can change and update it and you don't have to think about it a ton, and it's not really actively doing anything. A trust, and most people know them as living trusts in Washington, which is a will substitute. So when you die, it takes over, and at death, it performs much like a will. It says who should be in charge. That's the successor trustee. It says how things should pass, just like your will would. That part is very similar. The part that's different is that when you put a living trust into place, you can't just put it away and let it sit there. So we come up with the provisions that you want to apply, but then we have to look at your estate. So what do you own? How do you own it? What has beneficiary designations? What's just in your name? Do you own real estate? Is it in Washington? Is it somewhere else? We're looking at all these things. The point of looking at all the things is to identify these things have another way of transfer. So things with beneficiary designations often don't need to be part of the trust, sometimes, but not always. The other things, the real estate, the bank accounts that typically, you know, don't have beneficiary designations, and maybe you don't own it jointly with someone else, those things need to go in the trust. And so when we get you set up, we put the trust in place, we work together with you to put the funding, I call it funding, into place. So we prepare deeds for you to sign for your properties, to put them into the trust. We look at financial accounts and deal with your financial people to make sure that they get retitled properly if they need to be retitled properly. And then you leave. But in the meantime, your life is going on. So you're accumulating different things. You're selling assets, you're closing accounts, you're opening accounts, you're moving, you're just living your life, which is fine. But in the meantime, you have to remember that anything that you acquire that would cause a probate to happen needs to be acquired in the name of the trust. And anything, well, that's pretty much it. So you need to remember to do that. A lot of times when I'm dealing with the trust administration, so after someone's passed away and we're settling the trust like an estate, we call that trust administration. When I'm dealing with people on that, it's so common to find that 25 years has gone by since they set up their trust, and they have 3 different financial accounts in their name alone, not in the trust, and a piece of real estate in their name, not in the trust. And we end up having to open a probate anyway. So that's kind of one kind of cautionary tale about trust, why sometimes I think it's just not right for everybody, because it takes a lot of diligence and remembrance, and someone who can be very detail oriented to just make sure that they keep it up to date. But the other thing is that Washington has really good probate laws. So our government has pretty much identified here in Washington that probate should not be scary and time consuming and impossible for someone to get through, because they've recognized that we want to reward, and public policy should be in favor of people taking on the responsibility of settling estates, paying creditors, filing tax returns. That's all a lot of work. And the government wants you to do that because it's complicated if somebody dies and then just stuff is left. It's like there's a lot of loose ends out there. So we want to reward people for doing that. We don't want to make it impossible or completely cost prohibitive for them to do that. So Washington law has basically come up with what I call a pretty streamlined system. The laws are very straightforward, and if you read them, you can follow them. There are tons of resources to help you through probate, whether it's a website or lots of attorneys help with that too. And it's just not super expensive. In other states, like California is a great one as an example, because in California, their probate code is completely different. And when it comes to like attorney fees and executor fees, they have an actual schedule that applies based on the value of the estate. So if the estate is, up to X amount of dollars, $100,000 or $500,000, you pay this percentage of the estate to the attorney, and that same percentage again to the executor. And so in California, if you don't have a living trust, it's like malpractice for an attorney to let you not have a living trust. We have a completely different situation here. And I forgot to mention too, that what our government did end up coming up with was, when I was talking about non-intervention powers before. So when you go to court and you have the non-intervention powers and your executor can basically leave and just take over. It's funny because then they directly in the statute reference the rules that apply to trustees of a trust. So basically what Washington probate is trying to do is to say, once we've checked you out, we've said, yes, the will is valid. And yes, this person has not committed a felony and they're willing and able to serve. Once we've done that, we don't want anything more to do with this probate. We want you to handle it as if it's a trust. So, so we've got all that going on our side. You don't have to have a trust. You don't have to feel bad if someone comes up to you and says like, oh, we just set up this trust and you should totally have one too. And you're like, well, in your head, you're like, I don't think I'm that complicated. I probably don't need a trust. You're probably right. But it never hurts to ask. And I usually end up having, a conversation with people just to figure out what are your objectives, what's important to you, what do you have, and then we go from there. Dorothy.
Okay, I'm going to take the other side of that on a living trust versus a will for different reasons.
Yeah.
So having gone through the estate process with a lot of clients now, because the clients have been with us for over 40 years, the psychological and emotional aspects of going through probate for a 50-year marriage is overwhelming.
Yeah.
And a lot of clients cannot do that and don't do that. We have a client that finally closed the probate after 10 years.
Oh, why was it 10 years?
Because her husband died premature death and unexpected, and it was just difficult. Just totally difficult. So I've full disclosure, I've had a living trust since 1997 by myself. It's just easier for me. But I just tell clients that the cost is about the same, the probate and the living trust. It seems to me in my experience, but you're just doing your estate planning up front while you're both healthy if you choose to do a living trust.
Yeah, and I think for some people it makes perfect sense, and they are very capable of keeping their trust updated and maintained. And then you have to have one of those people that is going to keep everything in the trust. Yes, and I agree with you on the stigma, because I think there is just such a stigma associated with probate that it's like almost just defeating to people to hear the word, which is a lot of my job is just, when we're like, okay, sometimes even people with trust come in and then I figure out what they need to do. I set them on their way, and then I get a call, 2 weeks or 2 months later to say, oh, we found this one account. It's not in the trust. We have to do probate now. And they're just like totally defeated. And I'm always like, either way, it's going to be worked out just fine.
Yeah.
Either way, the process is going to be very similar. So you're going to be doing almost all the same kind of procedural things with the trust that you do with probate. But you're right, the wording is different. And sometimes it feels easier to people. I would say with married couples, though, if you're a married couple and you're interested in a trust and maintaining it, it is very simple from one spouse to the other to continue the trust on. It's just more at the final stage, and then just making sure that you maintain it properly. But and that is something, you're totally right. When there's a surviving spouse and they find out that they do have to open a probate, that is not the funnest news for them to hear, because they've already been dealing with a lot. So I think the point, though, is that it's really important to understand kind of all the ins and outs of it and what's right for you, because some people are just, I have clients sometimes sitting in here, we're talking about a trust, and they're just completely overwhelmed by the idea of a trust. So, like, what does this mean? How does this work? And I think above anything, it's like what I think about exercise. When you're considering an exercise program, you want to pick something that you like to do, right? And that like makes sense to you, and you're gonna keep doing it, because that's really important to just keep doing it. And with estate planning, I think pretty much the same thing. I think it's what makes sense to you, because all of these different methods, they all work. They all work perfectly well. They all have pros, they all have some cons, they all have a cost associated with them, so we just want to find the one that works the best for you, that makes the most sense for you. You can understand it, you feel comfortable with it, you can read it, those are all really important things too.
Brianne, I hate to interrupt, but we do have a question
Sure.
from Kathy Tashiro here with her hand up. I wanted to make sure you got it. We've got about 5 minutes left today, so just want to keep close on time. So Kathy, there you go.
Thank you. I just wondered what you think about, I know that there are professionals and maybe attorneys who can be named as the executor or attorney in fact, as opposed to the spouse or something like that. What do you think about that as far as settling the estate as a method?
Yeah, I again think that's the same kind of thing. What makes the most sense for your estate and your people? And that is something that has become more and more common over the past, I'd say 15 or 10 years, simply because oftentimes when people are appointing, let's say, a spouse or a sister or a friend to be their executor, they know that the person is competent, but they maybe aren't putting in their framework how much liability is associated with being a fiduciary. So being an executor carries a lot of liability. You have what's called fiduciary duties to everybody that you're working for. So, and there's a lot of law that governs that, and a lot of people don't understand that. So number one, that's part of it. Another thing is just sometimes it's really hard to put people that we know in charge because of the relationships with other people in our life. So if you've got 3 kids, and it's very common for people to name one child to be the executor, and then if that person can't, then another person. And that can just create a dynamic in the relationship that might not be comfortable, especially if you have family that already has some issues going on. Then looking to a professional can be awesome, because it makes someone who's objective, right? They're looking at your document, they're looking at the facts, they're going to try to administer it as objectively as possible, and it's not family against family. But the other benefit of having a professional is that generally they have insurance that covers what they do, malpractice insurance. They have information on how to do their job. They have education about how to do their job. There's people who are backups to them. If the person who's in charge, something happens to them, they've got a whole team of people who can step in and know all the same things and can take over where that person left off. So I think it's a great idea. And there are different types of professional fiduciaries. So you could look to an investment company's trust department. You could look to various CPA firms. Some attorneys will do it.
Are there, I just wonder if you have particular people or firms that you've worked with that you refer people to.
Yeah, there's a CPA firm in town who I've had actually quite a lot of clients have come to me from them, or have hired them, and they do a great job and are really reasonable. And those kind of people usually just charge for their time. versus when you're looking to a bank trust department, they're generally going to be charging a percentage of assets under management. And then there's a couple tricky things with investment company and bank trust departments in that typically there's a minimum that needs to be met. So your estate has to be a certain size before they'll step in and handle it. And then oftentimes they also want to take assets that you have in different places and put them all together under their umbrella, which maybe
Right.
that's totally fine.
That's not what I think I would want, but are you willing to name some of the people you've worked with that or recommend?
Yeah, so there's the CPA firm that I've worked with in the past is called Sutton McCann, and they do a really good job.
Could you put that in the chat maybe and spell it, or have someone do that?
Yeah, I can do that. But there are a lot of, it depends on where you are and what your needs are as to who might be a good fit. And I don't know, Allie, do you have anyone that you guys have worked with that you would recommend?
We might, what we could do is anyone who wants to stay on after the session, we can chat a little bit more about the specifics and specific names. If everyone's interested. And I know, Brian, you have your contact information up at the end for everyone to take down as well.
Yeah.
Sutton McCann. Okay, Katie just put it up.
Kathy, I need to go about at 4, but I have a name for you that I've worked with for a while, and it's a good contact, a good reference to.
Yeah, you may have given them to me before. I think I.
Oh,
well,
yeah, I think I did. Yeah.
So you definitely, I think talking to your people too, like if there's somebody that Dorothy and Allie have worked with and they have a good relationship with, that's a good choice because they will be working together. So you do want to talk to people that you work with and make sure that, it's a team that will work well together.
Thank you.
Does anybody have, I'm gonna stop share for just a second and see if anyone has any questions I can answer, and then I'll put up the final slide in a second.
We have all of our investments through Insight up in Washington, but we are now residents of California.
Okay.
Does that present problems? Is that any issue, or do you recommend that we work with a firm down here?
I can't really advise about financial planning. If you're talking about estate planning, you want to work with an attorney close to where you are. Yeah, so especially if it's a different state. And I would say that too, whether you have your estate planning done, or let's say you have it done and then you move to another state, if you have it already done, you want to talk to an attorney in the state where you are, because they can look at it. Maybe they need to tweak it a little bit to make it work, or maybe the laws are just so different that they're going to have to start from scratch. But yeah, you definitely want it to be based in the law where you live.
Okay.
Yeah, and in regards to financial planning, so whatever the primary address is on your tax return, if it's Washington or if it's California, that's going to be the jurisdiction that will be taxed, and also where your estate planning will go through. So some people could live in Arizona, but their primary residence is still Washington.
Right.
Or you moved your primary residence to California. In regards to investment management, financial advisors can work in multiple different states. So there really isn't, unless you want a financial advisor that you can physically walk down the street and go into their office as a brick and mortar, then that would be a reason to have an advisor in state, but you don't have to have an advisor in state.
Okay.
Yeah. Okay, so I'm going to close us out. We are at 4:03. I noticed we've had a few people flitting in and out. So just wanted to say thank you to Brianne for speaking. We're going to stay on for a little bit for anyone that has questions. Also, we will send out Brianne's contact information, and I believe she might have a slide to share as well with her contact info.
There you go.
Really great information, really great questions. And thank you all for joining us. Just wanted to let you know we do have a Wisdom with Women coming up in August on retirement planning, some cash flow considerations and other considerations leading up to retirement, Medicare, Social Security, pension planning, and cash flow planning. And then November, Dorothy Lewis will be doing a Medicare planning session. And then on June 15th, Financial Insights is doing their open house and late business anniversary post-COVID. So everyone's invited to come down to our open house. We remodeled a new space downtown. We'd love to see you. So Brianne, if you have any lasting comments, and if you're willing to stay on for anyone that wants to stay on and chat with us. So thank you
Yeah,
for
of course.
attending.
Yep. I'll stay here and answer any questions. And thank you for having me. I love talking about estate
Thank you.
planning. And for
Thank you.
everyone who's here, if you have any questions that are private and you just want to ask, you can always call or email me, and I'm happy to be a resource to you.
Thank you,
That was
Brianne.
fantastic. Thank you, Brianne.
You're welcome.
Thank you.
So Brianne, I don't have a question, but I do have a comment, and that is when my mother passed away, she had set up, there were 4 of us at the time, 4 siblings. She set up my older brother as a I don't know what executor, co-executor. And she set a fellow who used to be in the trust department of a bank who set up his own business. So there was a professional, a fiduciary, and a member of the family involved. And that went, I would say, very, very smoothly. When there were questions, there was a professional right there at hand to take care of it. So
Yeah.
that's just an idea, just a thought that happened that I thought it went very smoothly myself.
Yeah, no, that's a great idea to do that. Sometimes you can accomplish that just with having a person be appointed, but knowing that they're going to be working with a certain attorney to help settle the estate, then they can kind of work together like that too. But I agree, sometimes with siblings, it's just nice to have someone who's not related to the family to step in and be a decision maker.
Well, we still have 13 people in here. They've either left their computers on or they're just really wanting to listen to all the questions that come up. Either way, fantastic.
I have a question actually for Dorothy. The people that you referred me to, I didn't think they had a legal background. Is that has not been a problem as far as your experience with them?
I'm not sure what happened to my video, but anyway, I'm not sure. No, because what I do is prep the client for the estate planning attorney and or go with the client to the estate planning attorney. And oftentimes the person that we use will go to the estate planning attorney with us that is named in the document. So no, it hasn't been an issue at all.
Allie, on a personal note, could you say hi to Mike for us?
We would love to say hi to Mike for you.
Okay.
I think Amanda, she's not here any longer, but Amanda was on the line too. She works as an advisor really closely with Mike as well. I don't know if you've met.
We miss them, but we stay in touch.
Yeah. Well, so you're down in California, Faith, is that right?
Correct. Yes.
And you're down in California?
Right.
Okay. When did you move down there?
Permanent. Just a little over a year ago.
Wow.
So,
well, you're very lucky. It's been raining here for like weeks on end. So you picked a really great year to move.
I agree.
Well, yeah, we're in Palm Desert, so it gets a little hot. It's over 100 today.
Oh, I would take it. But
yeah.
We'll tell Mike you said hi, but to answer your question, Mike and our firm, we have a big concentration of clients in Arizona, California, Florida, and a lot of different retirement states. And we make trips to all the different states to visit our clients once a year.
Really?
Yes.
Okay, I haven't been made aware of that. So.
You might, for example, Mike not make those trips. So if you're willing to meet with like one of the advisors that's traveling just to review stuff, then if you're willing to do that, then yeah, someone will come. I don't know if Mike's doing rounds, but a lot of us do go around to all the different states and meet with the clients. So that's always an option.
Okay, well, we'll tell them to put us on the alert list.
Cool.
I just I've got to run. Allie, thank you for putting this on, Allie and Dorothy. And Brianne, wonderful job.
She did do a wonderful job.
Yep.
And you know what, Rick? You deserve an award. Most supportive parent in Tacoma.
Yep, you deserve an award. Yep.
Well, I learn every time I listen to her, I learn something. It's always worth spending time with her.
It is.
Bye-bye.
Bye, Rick. Nice to see you.
All right, I'm going. Bye, everyone.
Bye, Dorothy.
Bye, Dorothy.
Good night. Thank you.
Oh, Brianne, this was great information. I've gotten into some, or is Brianne still here? Did she?
Yeah.
Okay. I've gotten into some community property related questions that come up recently. So a couple of things I've learned in the last 2 years. So number one, I learned that for clients that are over the Washington estate tax amount, that we do not want to put things in TOD because it makes it that we cannot fund the marital trust.
Yep.
Wow, didn't know that. So right now we're in the process of re-registering high net worth clients' accounts away from TOD just into normal, joint or community property, because we didn't realize that it wouldn't be a fundable source.
Yep.
So that is a huge learning for us this year. Second thing is that I never considered up until this year using the marital trust to assist with two people that have two separate children. I never considered using it for that strategy. To me, it was always a Washington estate tax strategy, not really a trying to protect my 50% strategy. So I'm kind of opening my mind to telling clients about that, to help them get it down to maybe their children. Because I do have a situation like that right now where I have a client who's concerned that their husband or wife, whomever, is going to spend the assets down.
Well, it's a concern. I mean, that's just,
that's and I do
real...
see that used, the marital bypass trust used for that purpose instead of the estate.
Yeah, all the time. So typically when we draft the marital trust, we put them in on a disclaimer basis, which means at the time that someone passes away, we can look to see the size of the estate and determine if we want to set up the trust or not. But in those types of situations that you're talking about, we don't make it a contingency. We just make it mandatory that the trust gets set up.
Wow, so you can make it mandatory in the will.
Yep.
Yeah, I think it's a really common misconception that community property means that 100% of my assets have to go to my spouse.
Yep.
They don't understand that there is some flexibility. So I think a lot of knowledge could be used there in that.
Yeah, I've run into it too, where people think 100% of my property is going to go to my spouse, but they have stuff that's separate property and they haven't said anything. And then their kids are actually entitled to a piece of their estate.
Yeah, I think that separate property agreement is not discussed enough for people that have different needs, and especially spouse, husband, that are in really wide age gaps. We have long-term care situations maybe where we have assets spend down. I think there's a lot of reasons that we could really think more about that. Yeah, definitely. Cool. Brianne, we love you. This has been great information. Thank you so much.
That was fun.
I have a quick question that was raised by the discussion you just had, and I don't know the legalese. I don't know if it's relevant at all, but so what would you need to do if you're leaving everything to your spouse, but you want your part of what you left to them to go to other beneficiaries when your spouse dies? Do you need a trust for that, or it's a separate agreement?
I mean, you can always go with, I trust my spouse and I know that my spouse is going to do the right thing. And that works out part of the time and not all the time. And if you want it to 100% work out, then you should have a trust.
It can't be like a separate agreement.
You aren't really allowed in Washington to make agreements about wills. So people are under the impression too, because usually a husband and wife come in to do wills, and we do what's called mirror image wills. The wills say if something happens to me, it's going to my spouse, vice versa. And then when I'm the second to die or we're both gone, it's going this common way, right? We've got 4 kids and it's going equal shares to 4 kids, or we each have 2 kids and we're just doing everything equal. But it's coming from whoever dies second is going to go that way. The problem is that if you die first and your spouse later gets remarried, they can change their will if they want to. I mean,
right.
A lot of times they wouldn't, but not always. And then sometimes it's not even really up to the person, because unfortunately, people cognitively have issues, and then they end up marrying somebody, and then that person has kids and those kids have opinions, and the family dynamics can get very complicated. So if it's something that you want to make sure happens, then you want to have a trust provision for that. And that could be in your will. It doesn't have to be a separate trust that you set up. It could just be springing trust that would come to pass when you passed away.
Oh, okay. That's confusing to me. So you're talking about a different kind of trust that
well, so the type of trust that are like a will substitute are called living trusts. And you set it up and then you are dealing with it and living in it. But there's also other kinds of trusts called testamentary trusts where you have a will and you just say, if I die, this gift that I'm making is going into a trust for this person, and here are the terms for that trust. So it's not immediately happening, but you have already set all of the parameters for it to happen.
Okay. Thanks.
Yeah.
Cool. Well, thank you, everybody. Wonderful discussion.
Thank you,
Love
Brianne.
it. Thank you,
Thanks,
Brianne.
Ally.
I think we will send this recording out onto our Facebook and YouTube and our website, as long as you're agreeable to that, with your contact information with it. And normally we'll do a thank you and send that out to everyone. So if you want to add anything to that, let us know.
Okay.
Yeah, and if not, everyone have a wonderful rest of your day.
Bye,
Thank you.
guys. Thank you.
Cool. Bye, guys.
Thanks a lot. That was great.
Welcome. Bye, Kathy.
Bye.